accident, the host state can be liable?
Certainly not strict liability.
Extend time by 5 minutes.
Thank you very much. Certainly not strict liability. This is precisely very obvious from the words all reasonable measures. And in fact, in all state practice since the 1950s and 1960s, even if there were breaches in embassy, even if there were personal injury caused, that would not entail strict responsibility as long as appropriate measures, reasonable in the circumstances, were taken. And perhaps it would also be pertinent to look at the Tehran hostages case, where Your Excellencies also mentioned that where reinforcement came within 1.5 hours, that would be sufficient to discharge the special duty.
Is that the Tehran hostages case of 4 November 1979, or you are mentioning the earlier case of 14 February 1979?
Yes, the earlier case. And that was a collateral remark made by Your Excellency. That is, even if the police arrived within 1.5 hours, that was sufficient. Here, the police arrived within 30 minutes. They vigorously discharged the duty. Of course, there was an accidental injury of the Third Secretary. Emergency treatment was given. That was accepted by the Third Secretary. And therefore, it submitted that there was no breach whatsoever of both Article 22 and 29.
There was no injury in international legal terms. In terms of international law, you submit there was no legal injury.
That is correct. Having disposed very quickly of the embassy incident, we then go on to the last contentious issue, that is regarding the nationalization of Sicilia.
Where is your standing?
Once again, as my co-agent has submitted, as long as a declaratory relief is sought by the respondent, the local remedies principle does not apply. And this is well accepted in the Upper Sicily.
I think both Donerville and Burgundy are parties to that. It's the International Convention for Settlement of Disputes.
Yes.
Why, I know this is a factual question, why shouldn't you go to that? Of course, the compromise is silent that. Why can't I sit, remedies or steps can be taken?
And isn't that a ground on which we can decline relief?
Two responses to that, Your Excellency. First, Article 42 of the Exit Convention suggests that exit can only have jurisdiction, firstly, when there is lis pendens, secondly, when there is consent by both parties. Here, we do not see any lis pendens before the exit tribunal. Secondly, there was no evidence to suggest any mutual consent by both parties.
There can be a lis pendens if you go and file a case there.
Of course, but that would require consent. And on the fact, we do not see any consent. Therefore, Your Excellencies have full jurisdiction to hear the last declaration. Your Excellency, there are 3 requirements for a nationalization to be lawful: public purpose, non-discrimination, and proper compensation.
The declaration that it was being done as an act of retaliation to what happened in Foundling, how would you describe it?
That is precisely what the respondent...
No, never mind what is precisely. How would you describe it?
That is a reprisal action.
As reprisal. And does that satisfy the second condition?
Certainly not. That would be discriminatory. There was no objective or reasonable justification for this reprisal action. There was no evidence as to why it was a telecom industry owned by a fraudulent company that was in particular nationalized. This was clearly on the facts based on extraneous, purely political reasons. And according to the US-Iran Claims Tribunal, BP Exploration case, whenever nationalization is based on purely political, extraneous reasons, this would render it discriminatory and not for a public purpose.
As a matter of law, can we rely on it?
Certainly, Your Excellencies are not bound by any decisions of the Iran-US Claims Tribunal, nor by your own, of course, advisory opinions or judgments. But of course, this would be very persuasive before Your Excellency because...
Why do you think we should apply it?
Your Excellency, as we all note, the law on expropriation and the law on nationalization...
Why should we apply the Iran-US Tribunal claim principles? Why should we?
The respondent is merely inviting Your Excellency to...
Why? Please answer the question. Why should we apply? That is an answer.
Yes, simply because the claims tribunal or any other arbitral tribunals are more specialized.
Isn't it because the rulings of this court must be consistent with international principles of international law? law, we should not have lopsided decisions. Wouldn't that be a better answer? We shouldn't have, so that there is consistency across the globe.
Yes and no, Your Excellency.
Why no?
No, because, for example, if the Iran-US Claims Tribunal is outdated, it was, of course, in the 1980s, 1970s, and 1980s. Your Excellency, if of the view that contemporary standards have already moved on from those tribunals, of course, it would be pertinent and a good thing to move on to reflect what is the current status.
So in your view, if no compensation is awarded for an illegal act, that should be all right.
This goes on to the compensation standard. And the respondent's submission is that international law, that is public international law, should be proper governing law.
You're not answering my question. You're not answering my question.
And Your
You're
Excellency's
answering some
question
other
was...
question which I've never heard. I've been asked.
And Your Excellency's question was...
I've already asked it. I said, was it your position then that an illegal act can go uncompensated? If you say by contemporary standards, we must keep changing. And then, so can we therefore disregard the Iran-US Tribunal Award because we must move on and say that an unlawful act should not be compensated?
No, Your Excellency. There's a difference in compensation whether an expropriation was legal or illegal. As Your Excellency is...
Time is extended by 1 minute.
If the expropriation was illegal because it was not for a public purpose or was discriminatory, the difference would be the degree of damages. Punitive damages could be given, and also future losses of damages can be given.
So you say there's a distinction between principle and quantum.
That is correct.
And you say, as a matter of principle, you are entitled to compensation,
Certainly.
and the quantum is something that we have to work out later.
Not later, but a declaration from Your Excellency that it should be in accordance with international law.
With the Chief Judge permission, I would like to ask the same question I asked your opponents about the customary international law position of the current thing. Is it Hull formula? Is it CERDS, or is it something else? And yeah,
And if it is something else, what is it?
What is it? Yes, of course.
If it is something else, what is it?
It is certainly not the whole formula. It's certainly not the CERDS. It is the modern standard of just appropriate compensation. Not the whole formula, because the cases of Topco, yes,
You have 60 seconds to wind.
certainly. Numerous cases from various arbitration tribunals and the US Claims Tribunal have suggested that it is not the whole formula. It should be in accordance with international standards, just and appropriate compensation, and in accordance with public international law because of the very recent decision of Eurotunnel 2007, which 5 eminent arbitrators and former president of the ICJ agreed that for state contracts, that is what we are dealing with here, the governing law should be public international law instead with says domestic law. So unless I can be of further assistance, those are the submissions of the respondent.
Thank you.
Thank you very much.